wanted to say a little bit about Vince Davis, who has been my attorney. My case turned out to be a little more severe than what we had all realized it was. And with that being said, he is a attorney who goes above and beyond and is the cream of the crop, in my opinion, with what he does and how he does it.
Good morning, this is Attorney Vince Davis. Welcome back to CPS Office Hours. And today's topic is one that every parent asks me at some point in time. Can I sue Child Protective Services and the social worker? The short answer to this is yes, but there are rules, exceptions, and strategies you need to know. And it's not something that I would advise you to do or try to do on your own. So if you've ever felt wronged by CPS or seen someone else go through it, stay tuned. And if this live stream helps you, please consider donating. Your support keeps us sharing this information and fighting back against injustice. We have a little ticker at the bottom of the page, and it will show you how to make a donation. All right, first part. The answer is yes, you can sue CPS, but not always. Let's start with the truth. Yes, you can sue CPS, but not in every situation. There are laws that protect CPS social workers from liability, and that's called immunity. There are two types of immunity in our country, in our state. Number one, absolute immunity. This covers actions like filing court documents or testifying. Number two, qualified immunity. It applies to investigative work, interviews, visits, etc. To sue CPS, you need to show they violated a clearly established legal or constitutional right. Let me give you an example. If CPS removes your child without a warrant and without exigent circumstances, they will have violated your 4th and or 14th Amendment under the Constitution. And pursuant to those violations, you can sue CPS. So that brings us to the next question. When you have a case, you might have grounds to sue CPS if they, number one, removed your child without a court order. Number two, they fabricated evidence or lied in reports. Number three, denied you due process. Number four, retaliated against you for asserting your rights. And number five, if they have somehow personally injured you. Yes, I have been involved in cases where the CPS social worker has either attacked or abused a client, a parent, and in some cases, allegedly a child. These types of lawsuits and cases are usually brought under Title 42 of the United States Code Annotated, Section 1983. That's a federal civil rights law, and people usually refer to it as a 1983 action. There's a famous case here in the Ninth Circuit in the Western United States called Wallace versus Spencer. I think it's a 2009 case or 2000 case, and you can go ahead and Google that. But the court ruled that CPS violated parents' rights by removing a child without a warrant or court order. So what do you need to do to file a lawsuit? To file a lawsuit against CPS, you will need, number one, strong evidence, emails, reports, audio, video, court transcripts. You will need a timeline of events. You will need the names of people involved. For example, the social worker, the supervisor, the police. And you'll need a legal theory. What constitutional right was violated? You also need to consider the statute of limitations. In most claims, especially here in California, you have 2 years from the date of the violation to file. I get a lot of calls from people where the violation happened 10 years ago, 5 years ago, and it's simply just too late for you to file a lawsuit in most cases. And I like to file these lawsuits generally in federal court. Now, you can file these lawsuits directly in your state court, but I like, for strategic reasons, to file in federal court. The difference between federal court and state court can be numerous and can be important. One of the differences is state court has, in California, the California Evidence Code, which is different from the federal rules of evidence. In state court, they have the Code of Civil Procedure, which is different than the federal rules of civil procedure. And most importantly, here in California, in a state jury trial, you need 9 out of 12 people to agree with you and to give you money. In federal court, it's 12 out of 12. So what can you expect from a CPS lawsuit? The lawsuits take time. They are not overnight victories. You should expect delays, motions, and resistance from the county, social workers, and their attorneys. Be prepared for having your deposition taken and be prepared to respond to written discovery. This will take a lot of your time and a lot of your attorney's time. If successful, you may get monetary damages and legal fees. Under Section 1983, you're entitled to damages, you're entitled to punitive damages, which is a multiplier, and if you prevail, you're entitled to legal fees. But more importantly, you may force real change. Counties take notice when they get sued. Policies change. Workers will have to think twice when they deal with the next family. We've helped parents sue and win, but these cases require commitment and good preparation and a lot of work. So you can sue CPS, but you need to understand the rules, you need to gather evidence and proof, and you need to act quickly. If you think you have a case, talk to an attorney who understands both dependency or CPS court law and the civil rights laws. And remember, you can learn more about this topic in my Fight CPS School, SKOOL. We have live webinars, documents, templates, downloads, and court strategies for these types of cases. If you found value in today's live stream, please consider donating. Every contribution helps, and it helps us continue to expose injustice and supporting families across the country. I'm Attorney Davis. This has been CPS Office Hours. Stay strong, stay prepared, and we'll see you tomorrow. But before we log out today, I want to look and see if we have any questions. Okay. Mepatologita, hope I'm pronouncing that right, from YouTube, who happens to be a YouTube member of my channel, says, what are exigent circumstances? Exigent circumstances are emergency circumstances. For example, if a social worker sees that a child is being beaten by the parent, that worker doesn't have to go get a court order or a warrant to take the child out of your custody, because they see that there is an emergency that must be resolved. Exigent circumstances is not always apparent. And sometimes when social workers say that there's exigent circumstances, there really aren't exigent circumstances. Let me give you an example. Not too long ago, I did a case where the family home was raided by federal law enforcement. They call in CPS to take the kids. The only problem was at the time that the kids were taken, there were no exigent circumstances. All these federal law enforcement officers were at the home. The kids were in no danger. And prior to the law enforcement being there was no danger. So, um, if they don't have a warrant to detain the children, which I don't think they do because they won't give me a copy of it, um, they detain those children illegally. They should have gone and gotten a court order or warrant, which could happen, within an hour. The FBI agents and federal agents were at the home for an extended period of time, and that's what they needed to detain the children. But from what I understand, they didn't do that. So the family, the children, have claims under 1983 for civil rights violations. Min Dorothy Cook from Facebook says, Good morning. Good morning, Miss Cook. Okay, Mi Potolita again says from YouTube, can you as an attorney jail a foster father that sexually abused a foster child? You can't personally jail the person, but you can make a report to the law enforcement authorities, and um, the foster father can be arrested. And by the way, that happens a lot in the foster care system, where a foster parent, usually a father, has allegedly sexually abused a foster child. So much so that there's a special fund that covers foster parents or pays for foster parents who have abused uh, foster children. So if they don't have insurance or they don't have money, there's a fund, at least in California, that you can go tap into to be compensated. I suspect other states are like that, but I don't know for sure. All right. So from Facebook, we have Colina, maybe. If we file after the kids are returned, do we have to worry about them trying to take them again? I would normally say no, but is there ever retaliation? I will say yes. I'm involved in a case up in Northern California where there seems to be a little bit of retaliation. But I actually spoke to someone the other day where the kids returned, the case was closed. The parents filed a civil rights lawsuit against the social workers, and then the social workers decided to go back and detain the children. Not smart on the social workers' part. By the way, in that situation, I advise the parents to talk to their attorneys to have that case moved outside that county to another county, or have the state of California take over for the county of blank for prosecution. There are laws in California that sometimes the county can't prosecute you in a CPS case, just like they can't prosecute you in a criminal case. And then the state has to come in and take over the case. Okay, Colina says, also is a picture of the worker texting and driving with the kids in the car in the pouring rain down the 2-lane highway good evidence? Colina, good evidence of what? It's not good evidence for you to use in your CPS case, and it's not, it's probably not good evidence to use in a civil rights case. But if you want to report the social worker for doing that and you have evidence of it, go ahead and report them. Meeple Hita says, do you mean from YouTube, do you mean like bruised, beaten child like Anthony Olivas or Gabriel Fernandez? Yeah. And even not to that extent. The two names that she's mentioning are children that died because of CPS, allegedly because of CPS inaction or negligent actions. Colina from Facebook says, is it typical for a worker to find out we've been given visits by other workers and then take them away from us? The visits, that is. Is it typical? No. Have I ever heard of it? Yeah, many times I've heard of that. Um, I'm involved in a case right now where a social worker was removed from a case, presumably for good cause, according to my client. I came on the case late. And I realized at the next court hearing, I called her as a witness, and I realized that she is still making decisions on the case. So, yeah, retaliation can be real. Men from Facebook says, what is the longest period of time a parent has to file a civil rights case regarding civil rights violations, among others? That's a good question. Um, Here in California, it's 2 years. But the key is, when does that 2 years start running? And then when does it end? Because there's something in the law called equitable tolling, which means your 2-year period can be extended. So it tends to be kind of a complex legal question. But I always tell people to be safe, try to bring the lawsuit from 2 years from when they took your children. Okay. Melapita from YouTube says, like seeing their poor beaten faces. Yeah, that was a very sad. That's a very sad story. Two very sad stories. Colleen says, ask question, how do I donate to your channel? Oh, what a great question. If you see down below, there's a ticker running across the screen, Colina. Okay. And it will tell you how to make a donation through Cash App or Zelle. And it will gives you my mobile number where you can send that donation to. All right, Tony Tiger, looks like you're a member of my YouTube channel as well. So if you remember, I would definitely have to answer your questions. Tony says, my son was in the hospital for suicide because I took it so far as to get a lawyer to threaten the hospital with going to the Supreme Court to get my son released. CPS is pressing neglect charges against me. I hope your son is still in your care, in custody. And if you need any information, please give me a call, Tony. That sounds like a very interesting story. My telephone number should be on the screen there, 888-888-6582. Colina says, how do we remove the worker from our case? Well, that's actually a good question, Colina. I hope you're in California, because in California, there are code sections in the Welfare and Institutions Code, how to make a motion to remove your worker from your case. You know, you can remove your worker for bias, prejudice, for a lot of reasons, but you got to have good evidence to do it. You got to bring that to the judge's attention, and you can make a motion to change workers or to get a new worker. Me Palita from YouTube, how can access that child sexually abused found for my child? I don't understand your question. How can access that child sexually abused found for my child? I'm sorry, I don't understand your question. If you repeat it, I'll try to get back to it. Tony says from YouTube, I've had domestic violence in past. One of the reasons for neglect, but it was for 6 or more years ago. I have stayed. I lost you. Tony, I lost your question there. Oh, there it is. I have stayed single does not help my case for the part that is based on me talking my son out of the hospital. You know, Tony, if this case started because you took your son out of the hospital and they're trying to charge you with domestic violence that happened 6 years ago, you and your attorney should make a motion to dismiss that count of domestic violence. And there's a case called In re Troy D out of San Diego. I think it was a 1989 case where it says you have the right to challenge any type of allegation made against you. And in my opinion, an incident of domestic violence 6 years or more from today, is not relevant. Tony says that his child was being held by the hospital and medicated illegally. Men from Facebook says equitable tolling, trying to bring 2 years from the date they took the children. Equitable tolling is a completely different topic. If you Google it, it is just a way to extend the statute of limitations from 2 years to 2.5 years, or 2 years to 3 years. So if you have to use equitable tolling, I suggest you be talking to an attorney who practices in this area. All right. Tony says, CPS has been targeting and harassing me since my son was in my stomach. He's 14 years old now in July this year. Can I use unfounded reports to prove a pattern? Yeah, you can. I don't know the strength of that evidence, but you can try to use it. Of course you can. But if you're trying to sue them, I hope you're talking to a lawyer, because you should not be trying to do that by yourself. Mil PTO says, how can I get the money for my sexually abused child in foster care? Well, you have to bring a lawsuit on behalf of your child. And you have to do that with an experienced civil rights lawyer. If you want to call me, give me a call, 888-888-6582. Colleen says, I sent donation because I appreciate what you do and hope you check out my story on my Facebook. Colleen, thank you very much. Sincerely appreciate it. All right, folks, we're moving to the end of the Colleen has posted her Facebook story. I will definitely look at it. All right, folks, we've come to the end of the show, end of the office hours. We'll see everyone tomorrow. Let me do this one last question. Mina says from Facebook, what if we can be proved they never had a warrant, court papers signed by a judge to remove the child, but removed for reasons of retaliation? Men, if you can prove that, you will probably win a lot of money. All right. All right, folks, stay safe. We'll see you tomorrow on office hours at 6:30 a.m. Pacific time. Bye-bye.
Vince has been an angel, I believe, in my opinion, for me and my family. I would not turn to anybody else. I believe that he is an over-the-top individual that genuinely is there to fight the good fight. I would go to nobody else other than Vince, and I give him my thanks for getting me and my kids where we are today and putting us at ease. Thank you.